Good morning, everybody, and thank you very much for joining our first panel discussion for the III conference. We're going to be talking in this first panel about workouts in countries with recently amended laws, and we're going to specifically be talking about Brazil, the Netherlands, India, and Hong Kong and mainland China. Before I introduce myself,
Sonya, we're going to let Deborah introduce, and then we'll start again.
Good morning, everyone.
All right.
Can we get everybody to take their seats? I know everyone's so happy to see each other. So I just want to take a moment. I know we've got a bunch of folks on the screen from all over the world, and not everyone's going to be with us tonight at the legendary dinner when we do all of the official thank yous. So before I hand this off to Lisa, who's going to MC today, I just really want to thank the organizing committee, the planning committee, our co-chairs who have done a tremendous amount of work. Not everyone remembers the history of this conference, but we were scheduled to be in Hong Kong in May of 2020. We canceled Hong Kong prior to the pandemic because of political unrest that was going on there. We delayed Hong Kong, we didn't cancel it. And the New York Organizing Committee got together on a moment's notice, pivoted, and planned a fabulous conference, and then the pandemic hit. So now they've done it again. They didn't plan just once, but twice, but I know the entire organization and all of you really appreciate all of their hard work. So we'll do formal thank yous tonight, but I just wanted to really thank, in particular, our co-chairs, Judge Chapman and Dennis Dunn, our planning committee chairs, Judge Glenn and Lisa Schweitzer, and that's the program committee chairs, and our planning committee chairs, Stephen Hessler and Judy Elkins. So thank you to them and the rest of the committee, and to Rich Levin, who is here, who planned the last one, which ended up not coming off, but a lot of it has come into this one. So thank you to everybody, and now I'm going to hand it over to Lisa, and I see we've got folks on the screen from around the world, so enjoy the rest of the day.
Thank you, Deborah. On behalf of the Program Committee Co-Chair, Judge Glenn, the conference co-chairs, Judge Chapman and Dennis Dunn, and myself, I'd like to welcome you all to the III's 21st Annual Insolvency Conference, and it's our first post-COVID hybrid international annual conference. Hopefully our last. We'll be back in person next year, but it's a special time to be together. And it's very exciting that we've been able to go on with the show for this conference. As Deborah said, it was quite a couple false starts last year, and here we are getting back together again in the room and for other people on the screen. And it's great that people actually are logging in from all over the world today, and so we're hoping that we'll have active participation from people in the room and from all over the world. Special thanks go out to all the members of the Planning Committee and the Program Committee for their work in making this happen, and also to Sherry Bedker, Jenny Kadehi, Brandy Gimmon, and Annika Wolf at the III for their tireless efforts in supporting this conference and supporting the III generally. We're of course excited about the diverse and interesting issues that will be covered on the panels in the next few days. We'll both tackle issues that have become more relevant in recent times, such as talking about practicing in the COVID era and the lessons learned, and particular challenges for MSMEs, restructurings, and other issues that have arisen more recently. And we'll also have panelists address other more long-standing cross-border and international issues, from distressed investing strategies to the litigation of cross-border cases. Thank you all for coming, live or online. And without further ado, we can start the program. A few announcements that you'll hear periodically throughout the day. For the virtual attendees, we want to let you know that there'll be a CLE code in the chat and Q&A boxes, and you'll need to join the chats in order to see the CLE codes. Please write the codes down and keep them for the online reporting form that will be sent to you on the last day of the conference. Also, for virtual attendees, there is a different link for each session, so you have to remember to log in and link in separately for each program within the day of the conference. The materials that support the different panels are on the app if you're in person and on the conference website if you're virtual. And if time allows in each panel, virtual attendees are welcome to ask questions through the chat function. They'll be read to panelists. And for in-person attendees, you can use the microphones on the stands. There's no need to turn them on. They're apparently on already. And so with that, we can start our first panel. I see we have everyone on the screen today. Panel 1 is the comparison of differing approaches to workouts in countries with recently amended laws. And as our moderator today, we have Sonya Van de Graaf. Sonya is a partner at Avonhurst and previously a partner in the London office of Morrison & Foster. She advises individual and group investors on complex capital structures across a broad spectrum of cross-border and domestic restructuring and insolvency situations. Her expertise covers a wide range of vehicles and companies with specialization in advising replacement trustees and boards of directors. She previously also was senior in-house counsel at Bear Stearns in London prior to the financial crisis. Sonya has participated in the UNCITRAL Working Group 5 negotiations to develop a uniform insolvency law for the adoption of cross-border insolvency legislation internationally. So without further ado, I'll turn it over to Sonya to start the panel.
Thanks, Lisa. Thanks, everybody, for joining us. It's so nice to see you, albeit virtually. And our first panel discussion, as Lisa said, is going to be on focusing on workouts with countries with recently amended laws. And specifically, we're going to be focusing on Brazil, the Netherlands, India, Hong Kong, and mainland China. So as I said, I'll be moderating, and we're very fortunate to be joined by 4 esteemed panelists from Brazil. We have Judge Daniel Canio. He's judge at the first Bankruptcy Court of Sao Paulo, Brazil, and is specialist in corporate insolvency. Thanks, Judge, for joining us. From the Netherlands, we have Christian Zijderveld, who's a partner at Houthoff, and he's driven some market-leading transactions for many years, including Lehman Brothers, Treasury BV, Oi, and Steinhoff. His recent experience also in oil and gas and retail sectors. Thanks for joining us, Christian. From India, we have Sumant Batra, who's managing partner specializing in insolvency and corporate law at Kesar, and he's also senior consultant to the IMF and the World Bank. Sumant, thanks for joining us from India. And last but not least, from Hong Kong, we have Look Chan Ho, who is a barrister practicing in corporate restructuring and insolvency with a focus on cross-border. He was recently recognized as one of the leading global lawyers in the Who's Who Legal. So today we're going to be focusing on 3 primary topics through the lens of these 4 jurisdictions. So the first we'll be focusing on what are these recent developments, both in law and practice. Secondly, why have we got these amended laws? What's the motivation for the developments? And then lastly, we'll be focusing on the cross-border issues. So starting with Look Chan Ho from Hong Kong. Look, can you start by explaining to us in what respects have the restructuring laws or practices in your jurisdictions changed or developed recently?
Yes, thank you, Sonya. And hi, everyone. Good morning. Just to answer your question briefly, the topic, whilst it's about amended laws, we actually do not have amended laws in Hong Kong, nor in the mainland, in terms of restructuring laws. What we have is still the same old in Hong Kong English law, which is essentially schemes of arrangement. However, that doesn't mean that there haven't been developments. In fact, there have been many developments, and the developments come from cross-border insolvency law. And I talk about cross-border insolvency law not in the sense of crossing national borders. It is crossing the internal borders between Hong Kong and the mainland. I'll come to that in a minute as to the recent developments on cross-border insolvency laws and why they are important. The reason why I do that in a minute is because I need to set out the structure and what drives insolvency and restructuring developments in Hong Kong, with a particular focus on the mainland. Many companies that are listed in Hong Kong are incorporated offshore. They are Chinese businesses. All their operating subsidiaries are in the mainland, but they have their listing in Hong Kong through a holding company incorporated offshore. And the typical group structure is something like this. You have a top co incorporated offshore, which is listed in Hong Kong. Below that, you have yet another holding company, and that company is typically incorporated in the BVI. And then below the BVI, you would have operating subsidiaries. Just to simplify a little bit, the operating subsidiaries are all in the mainland. The top co, which is incorporated offshore, will raise finance through equity financing because it's listed here, and it would also raise a lot of debt financing through the issuance of bonds, and of course would borrow from banks. When the group encounters distress, and we see many of them right now, it is the top co that needs restructuring. However, you cannot restructure top co without knowing about what is going on in the mainland, because that's where all the subsidiaries are, that's where all the assets are, that's where all the local creditors are in terms of enforcing against their claims against local assets. This is where things get interesting, because when a default occurs, one always has to look at a group restructuring. Therefore, you already have a question of coordinating any offshore procedures with mainland reorganization and mainland insolvency procedures. I'll come back to that in a minute. Now, as I say, when we talk about restructuring, we always look at the group. But in any restructuring, you always have to find new money. So what drives new money being injected to this type of restructuring, and why are we seeing so many of them here? And the answer is regulation, mainland regulation. In particular, the currency exchange regulation, because money cannot leave the mainland easily. However, if you have foreign businesses, such as listing in Hong Kong, your business being listed in Hong Kong, you need to do international businesses, then currency exchange become much easier. And of course, when you are in Hong Kong, there is no currency restriction. So many mainland businesses, investors, they like to invest in Hong Kong, and they like to have listing companies in Hong Kong. And therefore, as a result, many restructurings in Hong Kong are premised on the listing status in Hong Kong. So a typical scenario would be something like this. The company that is listed in Hong Kong will suffer distress. It will have issued bonds, and the company would have defaulted on the bonds. In order to get investment to restructure the company's indebtedness, what the company would do, and if the company is in provisional liquidation, what the PLs would do is to invite investors to come. The investors will want to essentially buy the listing status. But of course, the listing status is not something that could be sold or assigned in the traditional sense. It's not like a debt or claim that you can simply assign to somebody. So what you do is, in order to essentially buy the listing status, is you would say to the PLs or to the company that I, as the investor, will be prepared to inject X amount of money into the company by way of subscribing for shares. That I will subscribe for the majority of the company's shareholding, so that after my subscription, I'll become the major shareholder. So therefore, it becomes my company. But as a condition precedent to my subscription, I need to make sure that the money that I inject will be paid to all the creditors to settle all their debts. And of course, it will not be 100% repayment, as the discount is needed, essentially a compromise. So the way you do that is you compromise all the creditors' debts by way of a scheme of arrangement. Of course, many of you know what a scheme is. Therefore, by doing that, the company would compromise all the debts by using a scheme of arrangement, using money from the investors. After the scheme, the company balance sheet would have been cleaned up, and then the company would then issue shares to the subscriber. So the subscriber will become the new owner of the listed company, new major shareholder. And then after becoming the major shareholder, the subscriber can also inject some of his businesses into the listed company that he has just acquired. So by doing that, the company listing status essentially would have been sold to the investor, and the company's indebtedness would have been restructured or compromised. So this is essentially what drives many restructurings in Hong Kong, which is something that is quite unusual. In terms of developments, this is important, and how you make sure that the developments will continue, how the restructurings can continue. That's where the cross-border developments that I mentioned come in. If you would like to do restructurings in the way that I just described, it is no use for the investor to buy a listed company having completely restructured its offshore debts and yet leaving the onshore debts completely unsatisfied. On top of that, it would not be useful for the investors to simply compromise the onshore debts and then allow the creditors who are dissatisfied offshore. For example, you do a scheme offshore, you compromise their debts using a scheme of arrangement. There will be creditors who are not satisfied, who are dissenting, so they may be wanting to enforce their claims against the mainland assets, in the sense that many of the debts incurred offshore are guaranteed by onshore companies, so the onshore subsidiaries. So if you have a dissenting creditor wanting to enforce their claims against onshore companies, essentially your schemes would be prejudiced. You jeopardize your scheme. Therefore, that prejudices the investment. So it is one of the reasons why the Hong Kong and the mainland authorities have developed an arrangement whereby the mainland courts now can recognize and assist Hong Kong insolvency proceedings. This is the first time the mainland court or the mainland system opens its door to non-mainland proceedings in terms of recognition and assistance. And the only jurisdiction they do that for is Hong Kong. And that arrangement came into place in May this year. This arrangement, I briefly explain what the arrangement is, what the key features are. The first is that if you look at it's in the form of an opinion issued by the Supreme People's Court. It contains only about 24 articles. Nevertheless, it is a distillation of the three main cross-border insolvency regimes in the world. The first being the model law, the second being the EU insolvency regulation, and the third being the common law. So we in Hong Kong participated heavily in that process. I myself also participated heavily in that process with the Supreme People's Court to develop this arrangement. So essentially, it's a model law-based cross-border insolvency regime. So if you look at the assistance that could be granted, it's very similar to the model law. Another key feature is the use of coming. So as I mentioned, the arrangement only applies to insolvency proceedings and schemes opened in Hong Kong. But to what companies would this arrangement apply? It would be nonsensical if the arrangement only applies to Hong Kong incorporated companies. Because as I mentioned, most of the listed companies in Hong Kong are incorporated offshore. So the arrangement would be useless if it's restricted to Hong Kong companies. Now, one might say, well, it would solve the problem if the arrangement applies to insolvency proceedings opened offshore. So let's say a Cayman or Bermuda liquidation or provincial liquidation. But of course, the mainland system wouldn't do that. So, and then the mainland court would never recognize insolvency proceedings open in those jurisdictions. So the way it works is it allows recognition and assistance to be granted to those companies that are listed in Hong Kong, proceedings open in Hong Kong, with one condition, which is that their COMI is in Hong Kong 6 months prior to their recognition for assistance in the mainland. So that essentially solves the incorporation problem. And COMI is not a problem because, as many of you know, the listing or the incorporation offshore is no more than a letterbox. So their COMI is undoubtedly in Hong Kong. So that's how the arrangement continues to drive insolvency developments and restructuring using this insolvency cooperation mechanism. Mindful of time, one final thing I mentioned is in terms of future developments. While this is very new, what we do expect is that there would be plenty more cooperation between Hong Kong and the mainland going forward. Just give you an example. Very recently, for the first time, Hong Kong has recognized the reorganization proceedings open in the mainland in respect of the HNA group, and we would see this more and more going forward. One thing I would definitely see in the future would be the recognition in the mainland of schemes of arrangement in Hong Kong. One final point I mentioned is, no doubt throughout the session, many people will talk about the English Gibbs rule, and that Gibbs rule probably is not relevant to the mainland recognition of Hong Kong schemes. So I'll stop here, Sonia.
Look, thank you so much. That was such a fascinating canter through the developments in Hong Kong. And I think people would love to understand more about the policy of the mainland Chinese court to facilitate this kind of outflow of currency. But sadly, we don't have time for that, but that'll keep people thinking, I'm very sure. So thank you, Look. Christian, let's move to you now, because I know we here in the UK have been fascinated by the Voeux, as it's called, being developed in the Netherlands, and it's been mooted as giving the scheme of arrangement and the restructuring plan that we have here and that we've been so proud of in the UK a run for its money. So can you tell us how it's been going? It's been law now for the last, 10 months or so, and maybe you can tell us how it's been going.
Yeah, thank you, Sonia. Indeed, as of January 1st in the Netherlands, we have what is called in Dutch WOA. Of course, the acronym sounds nice, but I won't give you the Dutch word. What it comes down to, and better is in the international context, is the Dutch scheme. It's a framework legislation allowing a debtor to offer a plan to its creditors, but also its shareholders if it sees financial distress is imminent. And the legislation is relatively court light. The entrance threshold is not overly high, and what it allows you to do as a debtor is to classify your debts, so you can make a classification of trade creditors, financial creditors, shareholders, and you have a lot of liberty at that. And if one class that is impaired votes in favor, and the threshold is 2/3 in amount, so there is no head count, it's only amounts that count, then the court can confirm the plan if you think it's a good plan. So you have a cross-class cram down. And whilst you're in that process, you have quite far-reaching automatic stay provisions, so you cannot accelerate that you cannot terminate contracts. If you want to enforce as a secured creditor, you probably are barred. You can be barred. So it gives you quite a good framework. And there are also all kinds of safe harbor rules if you want to do some DIP financing. So that's it. It's been in place now for 10 months, and we have quite a slew of court decisions coming out of the Netherlands in this one. I think we now have 50 published court decisions. We have 4 published confirmations, and why I say published, this legislation also allows you to do a behind the screens restructuring. If you only target your financial creditors, you can make this a non-public process, and that means it's not out in the open. I know there are a few of them pending or going through the process, and simply there's no public knowledge about it, and the court decisions are not published or not published yet. But of the 50 published court decisions, 4 have confirmed, and luckily enough, although you may say that's not for the debt, there have also been a few rejections. So the Dutch courts haven't been hammering through everything. They're quite strict in it. The interesting thing about it, before I go into detail on what it is that most precedents that we have so far are for SME debtors. So we didn't have any big cases go through. For instance, we had the Steinhoff situation go through the Netherlands, but there the debtor opted to go through a traditional Dutch suspension of payments, which has a 100-year history going back to it almost. And I think the reason for that is that bigger companies probably want to wait until there is more precedent. And also although the average running time once the court gets in, once the start of the proceeding until court confirmation is only 3 months so far. But that probably has to do because these are all simpler cases. The maximum time you can take is 8 months. So once you start, you need to finish up within 8 months. So I think for bigger companies, it's still a bit of a waiting game, aside from the fact that the economy in the Netherlands is really doing well. So there is also lesser need to do 2 restructurings. But I must say that what we've seen so far coming out of the courts is that they handled it well. I think a lot of the rejections that you see came from debtors that were unprepared, did not do their homework, were just trying to avoid the inevitable, which is a bankruptcy case. So the courts are really stringent on that. But it's, the process has been an interesting one so far, and it's a good tool into the box. But again, we need to see how this will move. How this will move in the coming months if larger cases are going to come through.
Thanks, Christian. For us here in the UK, with our new restructuring plan, we've been looking at how the cross-class cram down has been working. I know you have the same tool over there to cram down a plan on an entire class or classes. And we've been finding here it's quite controversial, actually, the way in which our priority has been working. We don't have absolute priority as you do in Chapter 11. And so that's meant that, for example, we've had situations where senior secured creditors have been sharing the proceeds of the restructuring surplus, as we call it, with, for example, the sponsors. So we don't follow the intercreditor arrangements or the waterfall on insolvency, which I think would raise a few eyebrows in some jurisdictions. But the policy decision over here seems to be, so far at least, because we've only had ours for about a year, that it's for those who are in the money to choose how to share the proceeds of the surplus. Could you tell us how your priority works over there? Have you seen much?
We haven't seen that much yet. What we do have, our legislation has a relative priority rule. So the court cannot confirm if you deviate from the statutory priority rules unless you have a reasonable ground for it. So the example they always give, if you have an SME with the director also being the sole shareholder, and this guy put his, or girl, or whatever, put his livelihood into this company, and actually the company cannot survive with the owner also being in place, then it makes sense that you keep the same shareholder because it's so intertwined with the business that you need to do it. So that's the example they gave where you can deviate from it. But We've been preparing restructuring cases where in the end we didn't need to go through a scheme or anything because we got to a consensual deal. But this was exactly the point where we say, well, you have good grounds to deviate. What does it do? So we're not there yet. And I think also the big issue is, especially if you have larger restructurings, it's going to be interesting because I always use the theory of a freight train. If the case is significant enough and there's employment or national interest at stake, is a judge really going to kill a plan which has broad support, but where you deviate from the priority rules because you simply want to get rid of some junior debt and rather have the same shareholder sponsor aboard? I'm not sure where it's going to end there. And I think that's also the interesting thing about the Dutch scheme is it's creditor light. Sorry, it's court light. So as a creditor, you only have very limited options to interfere. You can go for an option which is quite novel in the Dutch structure, where you can ask for a restructuring expert. That's an independent party that can offer a plan instead of the debtor. But that's also quite a hefty decision, especially if the case is a bit larger, because you basically say to the debtor, well, we'll set you aside, we'll have someone else offer your restructuring plan. So for a court, that's a big decision to take. But the same goes if you have a good plan that is voted through by quite a few classes and the senior creditor says, well, I think it's a good idea, but you have this deviation in the relative priority rule. And if it's big enough, is a judge really going to be empowered enough, so to say, to kill it? That's going to be the big issue here. But unfortunately, as I said, most cases we had so far were pretty easy and only involved SME debtors, and then a running time of 3 months isn't that complicated, not that much of an issue. But we'll see how that, the jury is still out on that one.
No, we'll all be watching with great interest, I'm sure. And in terms of getting, dip financing and so on to ensure that the process can run smoothly, that would be another interesting topic to discuss, which we don't have time for here. In the restructuring plan, which is my point of reference, we're concerned about capital structures and how they're going to be funded going forward, if it's going to be up to the senior securer to choose how to share the surplus. But anyway, we'll see how that all goes. It's the jury is out. Well, thank you very much, Christian. Now let's turn to Brazil. Judge, can you tell us what developments you've been seeing there and how the courts have been implementing them?
Sure. Thank you, Sonia. Good morning for everybody in New York and who is online with us. I hope next year in 22nd Congress of III we'll be able to be together in person in New York or whatever it takes. Well, Brazil, as you may know, has recently implemented an insolvency reform, but this is not a new process in Brazil. The process of reforming our law has started in 2016 in the light of the crisis we were facing at that time. It was the worst crisis ever in Brazil at that time. Now we have the COVID crisis, so let's see what happens. But at that time, the government has realized that it would be useful for us having a more efficient insolvency regime in order to overcome the crisis. So the government at that time, the Ministry of Finance, has created a commission of jurists to draft this reform. I was appointed as a member of this commission. We drafted the reform in 2017. However, in 2018, we had presidential elections. So a new government came in Brazil. And so this process took a pause. And then in 2019, we resumed this process of reforming our legislation. The new government has created a new commission to redo the work, to review the work. And fortunately for me, I was appointed again as a member of this new commission. And finally, in 2020, we had our reform in place in Brazil. So it's important to note that our reform is not directly linked to COVID pandemic, but for sure, the pandemic has accelerated this movement. The legislator has realized the need and the urgency for a more efficient legislation on business insolvency. And I would like to point out two important features of this new Brazilian regulation or legislation on insolvency. We have many changes, important changes, but I would like to point out two changes. The first one is the creation of a pre-insolvency proceeding in Brazil. It is a new proceeding for give to the companies the opportunity of reorganize itself. So Brazil has adopted this new restructuring tool. It is not specific for MSMEs, but it's suitable for them. It can be used by big companies or small companies, micro companies, but I used to say that it's very suitable for micro and small companies because it is a very informal proceeding, low cost proceeding. It's a hybrid proceeding, mostly out of court with a minimal judicial intervention. So it's very suitable for micro and small businesses. And the idea of this new tool in Brazil is to offer an affordable proceeding that permits for a company to deal with the crisis in the earlier stage, before the crisis becomes so difficult to overcome. So the idea is to offer a restructuring tool which anticipates some of the advantages of a formal business reorganization, such as the moratorium and or majority rule. In the case of Brazil, we anticipate the moratorium only, and I will explain later. But without the costs and without the stigma normally associated to these formal proceedings. The judicial business reorganization in Brazil, our Chapter 11, is very costly, it's very formal, so it's not affordable for most of the companies in Brazil. The majority of the companies in Brazil are micro and small companies, so this kind of company cannot afford for a proceeding like this. So how does it work in Brazil? The debtor can initiate a mediation proceeding in a private chamber. After that, the debtor may seek for an order of stay of actions before the bankruptcy court, the bankruptcy judge who would have jurisdiction over a future Chapter 11 case. But we don't have Chapter 11 case yet. We are in this stage before. So the debtor initiates the mediation process in a private chamber, goes to the court, asks for a stay of action order. So if the judge intends that it's okay, so the judge grants the order of a stay. So the debtor will have 60 days to conduct the negotiation with creditors, with the assistance of a mediator, a professional in the area of mediation. And then after that, the judge may confirm the settlements, the agreements that they could reach during this period. And regarding to the dissenting creditors, they are not affected by these agreements. The dissenting creditors may resume their collection against the debtor after 60 days. So that's why I say that we anticipate the stay, but we not anticipated the majority rule normally in place in a business reorganization proceeding. So what is the Brazilian idea here? At the same time, offering an affordable restructuring option, allowing that small companies and medium companies can have access to restructuring tool, preventing the filing of formal proceedings, and at the same time, raising the level of success of the restructuring by dealing with the crisis in the earlier stages. So let's see how it will happen in Brazil. We are very excited with this possibility of giving this new, or offering this new tool in Brazil. It is not a new trend. This trend of the creation of pre-insolvency proceedings has started in 2008 in the lights of the financial crisis in Asia. So after that, the countries in Asia started to implement the pre-insolvency proceedings in their legal instruments. And Europe also, we have the Directive 1023 saying that the countries in the European Union have to implement pre-insolvency proceedings in their domestic legislation. And here in Brazil, we are doing it now. So this is one important aspect of our new legislation. But there is another one important topic in this reform. We finally adopted the UNCITRAL model law for cross-border insolvencies. So we were trying to adopt it a long time, and finally we did it. So we have implemented almost 100% of the UNCITRAL model law. We had only minor differences to adapt to our domestic legislation. And we had the first case here in Brazil. The legislation is in force in Brazil since January 2021. And we had one case, so far one case, involving a Singaporean company, ProSafe SE company. It's an oil and gas company from Singapore. The company has filed for business reorganization in Singapore, but the company has a subsidiary. It has one subsidiary in Brazil, has assets in Brazil, ships here in Brazil. So that's why the company sought for recognition here in Brazil. And the Brazilian court in Rio de Janeiro granted the recognition, saying that the Singaporean case process is a foreign main proceeding, and granted the relief, which is the stay of actions in Brazil to protect the ships in Brazil. So I would say that we have many new aspects in Brazil regarding to our insolvency legislation. We have many other aspects besides these 2 points I brought to you, but I think that those are the most important aspects we have to discuss in this panel. Perhaps in another opportunity we can discuss the other aspects too.
Judge, thank you very much. That was a very efficient canter through your major developments. I was interested to hear you say that in the pre-insolvency developments that you have, that there's a mediator and creditors can come to the table, but you don't have a majority rule whereby the majority can impose, for example, a compromise on the minority. So I guess I'm wondering, what would be the motivation of a creditor to actually agree if he is entitled to hold out?
Yes, I think the motivation is that the creditor cannot enforce their creditors during this period of time, 60 days. So if they cannot go after the assets of the debtor, they are incentivized to sit at the table and negotiate. And the debtor will have the assistance of a professional on mediation. So this professional has the skills to at least try to show creditors what are the advantages of having a good deal, agreement at that stage. Because the next stage of the crisis would be perhaps the filing of a judicial business reorganization. So if I don't want to be subject to a judicial business reorganization, perhaps it is a good thing for me to have a deal now and be prevented from the next step of the the addressing of crisis by creditors. So I think we have discussed a lot if we should anticipate it for this stage the majority rule too, but we have decided that it would be too much. So let's see how it works in Brazil, and then perhaps we will amend it our legislation to boost
Softly
this.
first. Yeah, makes sense. Okay, thanks very much.
Step by step.
Yeah. All right, let's move to India. Sumant, you've been sitting there very patiently. Thank you. Can you tell us about your new code and how it's been working and lessons learned, perhaps?
Well, thank you, Sonia, and very warm greetings to all, and thank you, III, for inviting me. Well, I think most of you would at least be familiar that in 2016, India overhauled its insolvency system and came out with a comprehensive insolvency and bankruptcy code to provide for the insolvency framework for corporates as well as individuals. The law in relation to the corporates was implemented from 1st of December in 2016. And it's been almost 5 years, but for 1 year of the suspension during the COVID. But in these close to 4 years, while the code has been in operation, and I'm excluding that 1 year, while it was under suspension, we've come a long way. We started with a bit of a hesitation, I must say, because there was a lot of skepticism. We haven't really had a very good history of implementing the laws, howsoever enthusiastically they may have been enacted. But this time, well, as I said, although we started a bit on a hesitating note, but very soon it caught the imagination of the entire country. And in a matter of 6 months, we could see that the entire banking sector had started showing confidence and faith in the new insolvency law, undoing the baggage of the past that they carried because of the bad experiences in the law that we then had. Now, this law that was implemented in 2016 provides for a creditor in control regime. It was a complete opposite of the debtor in possession regime that we had until then. What it also did was it introduced special bankruptcy tribunals for the first time in India. And it also created a discipline of insolvency professionals for the first time. Also, of course, a regulator to regulate the profession. So there were very many first times in this law. But in spite of all that and the fact that we did not have really much experience of these in the system, we did very well for ourselves. In fact, the kind of enthusiasm which the stakeholders have shown has actually rewritten the history, I might say, because this law, the way it was implemented, has no precedence of an equivalent in the past. I mean, the kind of political will that was shown to implement this law is just phenomenal. And what we have seen, therefore, in the first 4 years is a complete, as I said, political will of the government, where they have demonstrated a proactive approach to this and almost introduced 4 major amendments in the code to address the gaps and the the jurisprudence and the messages and the signals that came out of the jurisprudence that was developing. And that's quite unprecedented to be able to introduce 4 to 5 changes that quickly. And they were all welcome changes, I must say. The regulation itself saw a dozen changes, again, because the market was using the law so proactively, and there were so many experiences and learnings coming out, and the regulator was on his feet all the time trying to capture the learnings and addressing those in the regulations. And I think the icing on the cake has been the jurisprudence that has come from the courts, not just the bankruptcy tribunal or its appellate forum, but also the Supreme Court, the highest court of the country. In almost first year itself, we had 8 major cases which set the path for the insolvency, cleared the constitutional challenges, came out with so many clarifications on the objects of the court, defining the powers of the stakeholders. It was just mind-boggling, if I may say. And 2 major changes that we saw, which was quite a big shift, was that in the last 1 year, we saw an amendment which made way for even the non-banking finance companies to be brought into this insolvency regime. And that was done by way of an amendment. And the second, which is most recently, is the introduction of the pre-PACs by way of a legislative framework, although for the time being it's been done for the small and medium enterprise, but it is expected that soon it will be open for the other companies as well. The jurisprudence in itself, although there are almost 50 major cases which are worth mentioning, but I would just underline 2 important ones. One on the cross-border insolvency law and the Jet Airways case, where in the very early days, the bankruptcy tribunal gave a judgment recognizing the protocol, and there was a major judgment by which the Netherlands and Indian professional, where we had insolvency going in both the jurisdictions for Jet Airways, we saw a cooperation being sanctioned by the court, and also for group insolvency. Again, a very large enterprise in the country, one of the largest conglomerate of group companies with offshore entities as well. The consolidation of insolvency, at least in terms of the consolidation of processes, was allowed, taking guidance again from the institutional effort on the group insolvency. So this has been very well. Now, one of the concerns lately, though, has been that because of the large number of cases that came to be filed, the bankruptcy tribunals got clogged with a large number of cases, and the decision-making slowed down quite significantly. And the government, unfortunately, could not keep pace by appointing the adequate number of the judges that were required to be appointed. But that correction has been made, and in the last 2 weeks, we saw 17 new members being appointed. And today, the government has come out with another appointment and advertisement to appoint another 14 members, so as to address the large number of applications that have been filed, a large number of resolution plans that are today being considered by the bankruptcy tribunals. So I would say that we've done very well for ourselves. We still have a long way to go, a lot of territory to cover. But I would say that the Indian, the stakeholders have defied their past track record with a poor track record when it came to insolvency law. Yes, I mean, one more point that I like to mention, Sonya, where I think we probably haven't really done enough, and we need to focus on, is to build the distressed asset market in India. We unfortunately don't really have a great amount of players in India looking to acquire distressed assets. We do have a good domestic market, but we really need some experienced players to come in and participate in the process. But I think that's also on the policy radar of the government, and we should see some traction there too soon. Over to you, Sonya.
Thanks, Sumant. Just in relation to your last point, I suppose it's the robustness of the pre-insolvency laws that will attract distressed investors to your shores. So I guess they'll all be watching closely, in the time to come to see, how comfortable they are, and the familiarity with which they can, assess the regimes there.
Yeah. Yes, I mean, yes, but in the meantime, at least the government of India has decided to set up a national asset reconstruction company, which has already gone off the ground. There is an asset management company which is currently being set up. So, till such time we're not able to develop an international market for that, at least the government is trying to fill the gap by stepping in and set up a state-owned distressed asset acquisition enterprise.
Right. Okay. Let's turn. I think we've got just a few minutes left. I want to give everybody an opportunity to say one last thing in relation to the topic, but I'd also like to ask specifically whether or not your jurisdiction has ambitions to become a regional hub for restructuring, or whether or not it's more of a local modest ambition to make your laws work for your own companies. Look, let's start with you. What's your view on that?
I don't think Hong Kong has any ambition as such to be a restructuring hub in the sense of making it a place to attract insolvency cases that do not belong to Hong Kong in the first place. The more important thing is actually to have a system that works for Hong Kong, and also to deal with the many international businesses that have connection with Hong Kong, in particular the mainland businesses, and they need a lot of help.
Thanks, Luke. Christian, are you going to be a rival to the UK scheme of arrangement?
We try to. No, it's no secret that the Dutch scheme tries to be a competitor with UK schemes, and that the Dutch jurisdiction would love to have more international cases in. But there's still a long road to go. I think one important element to all of it is that this new Dutch scheme still needs to be put on the relevant annex to the EU insolvency regulation. But that also brings in a whole host of COMI issues, so it's a bit of a duplicity there where the UK scheme doesn't have that issue. But I think the upside on the Dutch court system is you can confirm an English language scheme. There is no need for translations. Dutch courts tend to fare in Dutch, but there is no problem if English speakers are in there or translations need to take place. So we have the ability and the capacity to do so. But I think what we are lagging in is just to have enough precedent to say that it's a robust system, and it will take a couple of years to develop.
Yeah, it's still early days.
So it's still a bit out there. Yeah.
Mm.
But I think the ambition certainly is there, and I think the Dutch jurisdiction can do. Yeah.
All right. Judge, Brazil, ambitions?
Yeah, we have the ambition to be in the game. We have adopted the Untitled model law, so we are in the game now. Brazil has been using the Untitled model law actively, seeking for recognition for their outside. Now we are able to recognize proceedings, foreign proceedings too. So I think it will be very good for us in Brazil, for businesses in Brazil, and for Brazil to become internationally known as a good partner when it comes to insolvency proceedings and investments. So that's it.
Yeah, it's a signal that it's outward looking and cooperating. Yeah, exactly. Sumant, it sounds like the Indian market is extremely busy handling its own cases, but is there ambition to sort of reach out?
Well, I won't be able to speak for the policymakers, but I think speaking for myself, we need to focus on the Indian market and consolidate on our new law, at least for the next 3 to 4 years. We are a huge market and we have enough on our plate. We need to win the confidence of the investors globally and have their faith in the Indian system. I think everything else will fall in place. So probably a bit too early to comment on that is how I would put it.
Right. Well, thank you very much. I'm just checking if we have time for a Q&A session. I'm told that we need to close, which is a great shame. But hopefully there'll be delegates attending in person from some or all of these jurisdictions that we've been speaking about, and there can be discussion afterwards. Thank you so much, everybody on the panel, and to the audience for listening to us. It was great, great to be there.
Thank you, Sonia. I appreciate it. And thank you, everyone. Bye. Yes.